Welcome to Loopholes and Lawsuits. I'm Jamie
And
Schrabeck.
I'm Mike Vo.
Hello, Mike.
Hi, Jamie. It has been way too long. So it's always great to have these moments where we can catch up and share with our viewers what's going on.
We seem to say that way too frequently.
Life happens, work happens, and I think the last taping we had was at least 2 months ago, if not more.
Yeah, this is not our full-time job or we'd be starving.
I agree.
So I thought for today we could give a quick update on the status of legislation going through the California legislature, and also if we could touch on the lawsuit that you sent me. You have repeatedly and consistently and smartly warned people that this is what could happen.
A lot has happened in the last couple of weeks, at least here in California. There's been a lawsuit that was filed by a manicurist against several different nail salons. And I was made aware of it through a colleague. So I'm not the sitting attorney on this case, and I can give some comments and share with our viewers the life cycle of a lawsuit, what happens and what you can expect should you be filing a lawsuit or on the receiving end of a lawsuit.
I'm excited to have that discussion because we often don't have it. We talk about the threat of a lawsuit, but to be able to read through one and to understand what kinds of issues belong in a lawsuit and how it's phrased, I think would be very informative.
Excellent. So let me give our usual disclaimer before we dive into it. The information and advice provided today is not intended to be taken as and should not be considered as legal advice. No attorney-client relationship is formed through any of the discussions on today's podcast. You must consult your own private attorney for issues that are specific to your situation. Further, all topics of discussion are based on the law in effect at the time of taping. Please make sure to check for later podcasts of Loopholes and Lawsuits for any changes in the law.
Well, we talk about changes in the law and our disclaimer, and what's changed are the circumstances around bills that have been introduced. So originally, at the beginning of the session, we had a bill introduced by Assemblymember Tree Ta, AB 504, which was very simple and would have granted manicurists in the state of California a permanent exemption from the ABC test. That bill did not get a hearing in the committee it was assigned to. It was assigned to the Labor Committee, which makes sense because it's about employment issues. So in the meanwhile, that bill got stuck in that committee, and we moved from the Assembly side to the Senate side with another bill that had nothing to do with us, but it was the committee's bill. The chairperson of the committee has control over the contents of that bill, and that bill is AB 1514, and of course it's still alive because it is the committee's bill. They don't kill their own babies. And it moved over to the Senate side, and once there, it sat for a while and then was amended. And all of a sudden, we see this language that has to do with manicurists. We were given a heads up. We knew to anticipate some language, but until we actually see it in print, we can't really deal with it until then because it hasn't happened yet. And now that it has, this was the version of the bill that had a hearing in the Senate Labor Committee and was passed through, and now it moves on to the Appropriations Committee. So we can talk about what the language is. It's not everything that we would have wanted. It's not a permanent exemption, but it's an extension.
The proposed changes are to Labor Code 2778, sections B2L, and there's 2 I's and 3 I's where the changes are. And for our viewers, what's important to you is the expiration of that exemption has now been extended to January 1, 2029. So essentially, they've kicked the can down the road. This hasn't really resolved the issue. It's just been kicked down the road a couple of years. And then the other big part that I'm seeing in here is that as part of this agreement to kick the can down the road, so to speak, it's going to require that the EDD, the Employment Development Department, and the DLC, essentially the Department of Labor, has to provide reports to Sacramento on the number of complaints that have been filed by manicurists against establishments. I'm not seeing what the purpose of this reporting requirement is. Do you have any thoughts on that?
My thought is that they still think that we deserve this special treatment, which we don't deserve. If we're going to have any kind of reporting requirement at all, then it should apply to all beauty licensees. I wish they had taken this issue up with AB 504 in the first place and had a discussion about a permanent exemption. And if their issue is we don't know enough about our industry, then basing their understanding on reports, putting the burden on those who are exploited to make those reports, doesn't give a clear picture of what's happening in the industry as a whole.
Right. I can share with as a practicing attorney representing multiple establishments, I've taken the occasional employee claimant side cases. This reporting requirement that is imposed upon the EDD and the DOL, most of these cases are not reported. Most of these claims are not reported. The numbers are not going to be accurate as to what's going on in the industry. And I think it's just an extra burden that's been placed upon the state that is really unnecessary. But I do agree with you. What it does is it set aside the manicurist industry and almost is finger pointing and casting blame upon the entire industry that there's something wrong with the manicuring industry, separate and apart from the entire beauty industry. I still believe that there's separate treatment going on here, and there's really no basis to justify this reporting requirement.
I'd also like to note that we still don't have the licensed hairstylists included in the exemption. All of those more recent licensees who took advantage of the shorter 600-hour minimum hairstylist licensing course are not covered. They are not exempt. So we're still not applying the same treatment to all license types.
Right. Let's look at the practical impact and what's going on. In the absence of AB 1514, the manicuring industry is subject to the current Labor Code 2778, which states that there is no basis for independent contractors. So I think for many of our viewers, you're probably asking us, Mike and Jamie, really, bottom line, what does this do or don't do? Do you support it? Do you not support it? I think the extension back on the books, that's a great thing for the industry. You and I and all of our viewers are going to have the same conversation come 2028. What do we do here? That reporting requirement, I'm not so sure or even confident that anything's going to happen of it. Whatever they're going to report to Sacramento, they're going to report. But is there going to be any meaningful action taken by any of the government agencies in response to this report? I don't believe so.
Well, it actually will shine a harsher light on the labor commissioner's office than it might on the beauty industry.
Yeah, I think you're right, because this is not really an issue that is within the jurisdiction of the BBC. This is a Department of Labor issue. And as we've mentioned in prior podcasts, the Department of Labor, I question their enforcement of current laws. I question how they were interpreting the changes in 2778. So I think it leads to a lot of questions remaining as to what's going to happen over the next 4 years of this exemption coming back on the books.
And what happens to people who didn't make the change? Are they still vulnerable to having their practices subject to a lawsuit or a claim? Just because this is moving forward doesn't mean that everything goes back to normal right now. The law is the current law.
Right. The law is there's no independent contractor basis. And that will be the law until at least the very end of this year, until there's a change, which may come by way of AB 1514. I would recommend that all of our viewers who are in the manicuring space comply with the current labor code. Don't worry about what's going to happen come next year, 2026. Don't worry about what happened in the past year, 2024. If you are an active licensed manicurist and also a salon owner in 2025, you must comply with the current law.
Mike, I want to make an analogy. You mentioned that the number of workers who would report their misclassification, their wage theft experiences to the labor board rather than pursue private litigation. It's the same with claims of liability when it comes to consumer harm. The state board receives just a fraction of what happens with private litigation involving insurance companies.
Right. Most claims don't get reported. They're either settled between the parties, or oftentimes the claimants will just overlook whatever happened and move on with their lives. So that reporting requirement makes no sense to me. I normally see more activity in the realm of private civil lawsuits. Oftentimes it's because it's manicurists who've gone to attorneys who have a better understanding of what the current labor laws are, wage and hour laws are, and it is through the advice of their attorney that a manicurist discovers that, hey, I've either been misclassified and haven't been paid my proper wages, or maybe I was not misclassified. If I was an employee, I wasn't properly paid my wages. Interesting about a week ago, I was forwarded a lawsuit, a class action lawsuit that was filed here in the Orange County Superior Court by one individual plaintiff, manicurist, against several different establishments that she alleges she worked with between March of 2024 and March of 2025. And these complaints, these are public documents. Anytime you file a lawsuit in the Superior Court, that is a public document. It is only through subsequent procedural actions does a case move to arbitration or it's placed under seal. And just so that our viewers know, I am not an attorney on this class action case, either on the plaintiff side or the defense side, and I have not been approached by anybody to represent them. So I'm in a position where I can at least share my comments upon this case.
We will have a link to this lawsuit. It's fascinating to read through the claims and citing the law that it violates. You can't just say, hey, you did something wrong. You have to cite what it is that they did and how it compares to the law.
What I'm looking for is the general allegations. What is the claimant or the plaintiff alleging here? In this case, she's alleging she was a manicurist. She worked for the various defendant nail salons in this case through some time between March of 24 and March of 25, and that during the course of her employment, she was not paid minimum wage, overtime, not provided with meal breaks and rest breaks, wasn't reimbursed for business expenses. She wasn't given her final pay. She didn't get an accurate wage statement. These are very common claims that I see when I'm defending my clients in wage and hour type cases.
We're talking about a single named plaintiff, and yet this is a class action suit. Can you explain how that happens?
There's two types of cases. The individual case where it's one manicurist suing one salon or two salons, whatever the case may be. But here, the difference is that she's suing on behalf of a class, a group of manicurists who they're alleging were similarly situated and also underwent the same treatment, the same violations of wage and hour law. Now, just because the lawsuit is filed as a class action, it requires through subsequent processes that the court must identify the class and also certify the class. Most of the time when I'm seeing class actions, it's the one employee who's representing other employees who are similarly situated. So it would be that one manicurist who's trying to represent the other manicurist at that one establishment, where you have multiple defendants that are named, multiple nail salons. It makes it much more difficult, because how can you argue that, hey, when I worked at, in this case, I'll use some names here, Pure Nails, that establishment at Pure Nails, I was subjected to the same treatment as Crest Spa. And the folks that I worked with at Pure Nails were also subject to the same treatment at Crest Spa. I'm not the attorney on it. I'm just saying that I see some challenges. I see difficulties. But to relate it to our viewers, you can be the manicurist or you can be part of the represented class if it gets to that point in a lawsuit. Most class actions, again, I see it as against one defendant. Otherwise, it's very hard to assert that all these various defendants subjected you to the same treatment and your colleagues were subjected to the same treatment.
Right now, they're listed as defendant entities, not individuals.
Right. They're all entities. They're all entities here, but that's the challenge is parsing through, well, what happened at Pure Hair and Nails? What happened at Meridian Spa? What happened at Crest Spa? There are different corporations that this particular plaintiff alleges she worked at.
And when you say certify the class, Mike, does that mean that all the potential plaintiffs would be identified, or they could be added later, or they could be listed as Jane Does, or how does that work? How does it benefit someone who might have been a coworker and similarly situated to say, that applies to me as well?
Most class actions, and especially of the type that has been filed here, it'll probably be resolved by way of settlement. You know, if they're going to get anywhere near a class, I would be surprised in this case to get anywhere near a class. Most of the time, when I'm seeing class actions, it involves 30, 40, 50 potential class members. If these are smaller establishments, 2 or 3, I just don't see the class being clearly defined and meet the thresholds for class certification.
Mike, can you explain what might have happened up until this point?
Well, we don't know what the arrangement between the plaintiff and her attorneys, but it is not uncommon. Actually, it's very common in wage and hour employment cases, the plaintiff or the client has what's called a contingency arrangement with his or her attorney. You see a lot of times in auto accidents. So the attorney has an agreement whereby the law firm will get a percentage of overall recovery, either by way of a settlement or a verdict, whatever the case may be. So in this particular class action lawsuit, I would not be surprised that the plaintiff has a contingency arrangement with her attorneys and they get whatever percent, 40% of any monies that are recovered on the back end.
In a recent episode, we talked about having insurance to protect your business. So let's look at this from the perspective of the defendant entities. If I'm not mistaken, you said that that insurance is not going to cover you for your business practices if, in fact, you were breaking the law.
So when it comes to insurance for labor issues, there's what's called an EPL policy, Employment Practices Liability Policy. Most of those policies will cover harassment and discrimination. A lot of times they're accidental. They're not intentional acts. Someone may have said something they shouldn't have said. They mishandled a medical leave situation. It wasn't intentional, but it was mishandled. So in those situations, the insurance company will provide you with a defense and indemnification. With most EPL policies, they do not cover wage and hour claims. In other words, meal breaks, rest breaks, overtime, minimum wage. And the policy rationale is a lot of times those are intentional acts by the employer. We don't want to encourage a salon obtaining an EPL policy, hiring 10, 20 manicurists, work them to death, don't give them meal breaks, don't give them rest breaks, don't pay their overtime, and then when those same manicurists turn around and sue the salon owner, the salon goes, hey, you know what, I have an insurance policy. We don't want to condone or promote that type of bad intentional conduct.
Looking at the list of allegations, I'm curious why something like paid sick leave wouldn't be on the list.
There's more monies on the wage and hour components. There's penalties that go with it. So there's the actual compensatory side of things. Hey, you did not pay me. And then under various statutes, under various labor codes, there could be penalties imposed on top of that.
One of the things I found interesting was this whole issue of unfair competition. The fact that they point out that this salon, or I should say entities, benefited financially, had an unfair advantage by virtue of not paying employees properly.
Correct. In 90+% of wage and hour type cases, the plaintiff's counsel will add in a cause of action for unfair and unlawful competition where the defendant engaged in an unlawful, unfair, or fraudulent business practice, the non-payment of wages or improper wages. Because they did that, they had some other competitive advantage over other salons, and the plaintiff or the employee was harmed. Very standard to see what we call a UCL claim. The impact it has is that it extends the statute of limitation on wage and hour claims from 3 years to 4 years.
Oh, wait, say that again, because I think that's super important for people to hear.
So when you're under the labor codes and statute, the statute of limitation for wage and hour violation is 3 years. In other words, you go back 3 years on the alleged violation. So I tell clients, make sure you have 3 years of payroll records, time records, pay records, wage statements, whatever the case may be, because that's the statute of limitation. It goes back 3 years. Now, if there's an additional cause of action for unfair competition, that extends it to 4 years, one additional year. So that's why it's very common to see in wage cases an additional claim for unfair competition, because now the employee or the attorney is able to go back 4 years. That could be substantial sums of money, even if it's one individual plaintiff or a class certified group of aggrieved employees. To go back 4 years, and depending on the type of case, let's say you have 100 manicurists, that additional 1 year of alleged non-payment of wages, so you have the compensatory side of things, you got to pay them for what you owe them, plus that additional 1 year of penalties, which could be substantial in many cases.
Now, again, we don't know the details of this case. Neither of us are involved in this case. What do you think happened before this point? Do you think that this plaintiff approached these entities with a demand letter, and if you don't pay up, I'm going to file a lawsuit? So do you have any idea, just in general, how these kinds of cases proceed? Was this a surprise?
Maybe the plaintiff in this case would say, hey, you owe me wages. You didn't give me this and that. And the employer just dismissed the claim, didn't do anything wrong. The plaintiff could then go seek legal representation And at that point, the lawyers may have had a conversation or communication with the employer. Nothing happened, at which point they just filed a lawsuit. I mean, it's not alleged in here what they did or didn't do. They don't have to allege that. They just have to allege the claims for violation of the wage and hour laws. I have yet to see a manicurist case that has gone to the jury. I just haven't seen it. And I only practice here in California, so it could have happened in other states. But I think if something like that were to have taken place, it would have caught my attention. And I don't remember seeing that. Many of the salon cases, just because of the size of the defendant, they're going to settle. And the reason why I say that, it's very expensive to defend a lawsuit. Most of my clients faced with employment claims, from the time they are served with a lawsuit to the time we're finished with a trial, depending on the number of claims and the details that are uncovered during the course of the lawsuit, it could be a $500,000 in attorney's fees alone just to defend them.
Wow. That is sobering. That's got to be so much more expensive than actually paying.
Very cost prohibitive when you're not following the law. Just pay the proper wages. And I want to make sure our viewers understand, even though I'm a practicing attorney mostly on the management side, I am a firm believer. If you have workers who are putting in a hard day's work, they earn their 8 hours of pay them. They've done their job. You should pay them. I've been on that side too. I don't believe that salon owners should be shortchanging hardworking individuals. Now, if the individuals aren't working, that's a different story. But if they're working, they're doing what they're supposed to be doing, the salon owner should be paying proper wages.
It's an interesting read. And when you get into the details, it does go above and beyond just the wage an hour. It talks about doing business errands for the owner and not being reimbursed for those expenses, whether it's the gas or the money spent in retrieving supplies, that sort of thing. You can't use your workers in that way without having them be clocked in, clocked out, and compensated.
Right. And those are whole separate issues there. When you're starting to utilize employees for personal purposes, you're facing an additional amount of exposure outside of the typical wage and hour lawsuit.
And we've not seen the evidence, but I would imagine that if this person moved forward to this point, that they have record receipts of having purchased supplies, dates, times, whatever it may be. Either you have an accurate wage statement or you don't have accurate wage statements. Those kinds of things are fairly obvious, so it doesn't surprise me that a salon owner would settle sooner rather than later, because of course the longer it drags out, the more expenses they incur as well.
And, this complaint are just allegations. At this point, it's just allegations. There's been no facts, no discovery done. I checked the court's docket a couple of days ago to see if the defendants are represented or have made an appearance in the lawsuit. They're not even at that point yet. The plaintiff does have the burden of proof. She has to convince court or jury, whatever the case may be, these alleged violations occurred. Many ways to claim, and sometimes there's documents, sometimes there's not. There's always the oral testimony, which is evidence. From the defense side, I tell clients, salon owners, have your documents ready. If you're going to have manicurists work, clock them in, clock them out, give them their wage statements, onboarding documents, policies, procedures. All that should be complied with. The more compliance there is, the better the odds of resolving differences when a lawsuit or a claim of lawsuit is being made.
So the fact that this lawsuit could be amended, perhaps some of these allegations can't be proven, so it might get shrunk down or it could expand?
Correct. Some claims could be dismissed, some claims could be added. Too early on this case, and I'll do my job to kind of monitor it. I won't be privy to any of the discovery in this case. If a year from now we're talking about this case and this trial date set, I'd be interested in seeing if this is going to go to trial or not. Several years back, I want to say 2 to 3, there was a large case, Manicurists versus several different establishments, and it had gone through several attorneys, some claims whether the defense was mismanaged. I was approached by one of the defendants in that case to potentially take over representation. I looked at it and I said, you know what, it's going to cost you a lot more for me to take over. Maybe you want to explore resolution of the case. It made the headlines, the local media, and I think it was prosecuted by one of these organizations that champions and advances employee rights.
That reminds us all that compliance will always be top of mind, whether it's protecting our clients or protecting our businesses.
Compliance in every aspect. Ignorance of the law is not a useful defense. In court, you got to know, you have to pay. And whether it's employment law, wage and hour laws, whether it's business laws, You have to know all the laws that are applicable to your profession. So, word to the wise, comply, be educated, do your own homework. Jamie and I always encourage our viewers, do your homework. Do not listen to somebody on Facebook or LinkedIn or even myself. I know I'm an attorney, but do your own homework. See if what I'm saying is accurate or not.
Mike, thank you so much for our conversation today, and I look forward to talking to you soon.
Great. Thank you, everyone. We'll see you next time.